Hello and welcome, and thank you so much for being here. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. And thank you so much for being here. Welcome to another episode of Deportation Defense Live, everybody. We are live. So hello, everyone on Instagram and Facebook and TikTok and YouTube and LinkedIn. Thank you all so much for being here. I really appreciate it. Today I want to talk about the 6 most common mistakes in immigration court. All right? And so we'll get right into it. Again, my name is Otis Landerholm. Thank you for joining in. So I'm going to make our conversation short and sweet, fast and furious today. All right? So welcome. Thank you for being here. Deportation Defense Live is here to train, teach, inspire, and empower immigrants who are facing deportation to make the most out of immigration laws, to make the most out of their lives, and to win their cases. All right? Are you facing removal in immigration court? Do you know someone who's facing removal in immigration court? Because if so, you know that it is not easy. All right? It is an uphill battle. The laws are against us. And here at the Deportation Defense Live, we're here to maximize your chances of winning that case. Okay? Today our theme are the 6 most common mistakes made in immigration court. And, thanks for everybody for being here. We'll do this topic, and then once I'm done with the topic, I'll open it up for any questions if there are any. Feel free to submit your questions, all right? And then we'll wrap up and we'll do this episode in Spanish. Okay? So I'm going to jump right into it, and we're going to go we're going to go quick and dirty today, all right? So number 6, all right? This may arguably is number 1, but I didn't want to save it to the end. And I do think it's probably the biggest difference in success versus failure in immigration court. And that is, number 1 mistake, number 6 mistake, whatever, not having an immigration lawyer. All right? Have an immigration lawyer. You want an immigration lawyer. You want one who's good. You want one who knows the law. You want one who you trust. You want one who's going to put the time and effort into it to prepare you and to prepare your case all the way. Okay? If that is anything that you do not have, time to switch gears. That is fundamental. You need an immigration lawyer who's good, who knows the law, who you trust, and who will put the time in. All right? Number 5, we're going 6-1. And I'll put in a bonus for those who stick around. Number 5, mistake made in immigration court. All right? Are inconsistencies. What do I mean by this? All right? Inconsistencies in an immigration record can undermine your credibility. It'll make the judge not believe you, not believe your story. If a judge believes that you're lying or that you're not credible, you can be ordered deported just for that. All right? You don't want any inconsistencies. And now sometimes it happens. Oh, but wait, my lawyer wrote that declaration for me and told me to sign it. All right? Like, yeah, that's often the way we do it. That's often the right thing to do. But that's why having a good lawyer is so important. You can catch those kinds of inconsistencies at the outset before you sign the thing. You really want to review everything yourself. This is your case. This is your life on the line. You want to review everything yourself before anything gets submitted to the immigration court, but you want to do it with your lawyer. All right? You're working as a team to make this packet the strongest possible so that you can, fight for your right to stay in the United States. You want it clean. Don't have inconsistencies. They just cause confusion and they cause a judge to question whether or not you're lying. All right, you want to avoid that. Number four, fourth common mistake. All right, we've done 6, 5, we're now at number 4. Number 4 common mistake is not appealing your case, all right, or waiving your right to appeal. Don't do that, okay? Before you go to your individual hearing, to the final hearing in immigration court, have a game plan. Understand what you will do if you win. If I win, it means this, all right? Understand what you will do if you lose, all right? If you lose, if I lose, I will reserve the right to appeal my case. I know I will have 30 days to file an appeal if I choose to. That is a due process right that a person has. You do not want to waive that right, okay? The only time where people want to waive that right and where it makes some sense, even though it's tragic and horrible, is where a person's detained and they don't want to be detained anymore, and they know or they feel that they know that their chances of winning on appeal are very, very low, and they're just tired of it. All right? That's the only one situation, but even there, gosh, like, let's fight this thing. You know, don't give up. Don't give up on your case. So anyway, that's what I want everybody to know. All right, we're going fast. We're doing great. All right. So we've talked about number 6, number 5, number 4. Mistake number 3, I want everybody to avoid. All right. What is this? Mistake number 3 is not challenging the government, not challenging the government's allegations. Okay. Look. In a notice to appear, which is like the initial charging document that the government creates, they file it to the court and they have allegations and they have charges against you. But here's the thing. Sometimes the government gets it wrong. I won't say sometimes, I'll say often the government gets it wrong, which means that sometimes you can win your case just challenging what the government has alleged against you inside of the notice to appear. It can be a serious mistake not to challenge those allegations. Say, look, no, we deny allegations 4, 5, and 6, Your Honor, right? But you want to go in with a lawyer who knows that, all right, who knows what to do in immigration court. Anyway, challenging the government's allegations can be a game changer for you, and I want you to know about it. Okay, mistake number 2. We're going 6, 5, 4, 3, 2, 1, and then I'll give you a bonus. Okay? Mistake number 2 is not calendaring critical deadlines on your case. You may not know this, but different judges in immigration courts throughout the country have different deadlines, all right, for when all the documents are due before any type of hearing. You got to know about it, okay? The Immigration Court Practice Manual lists 15 calendar days before the hearing as the document deadline, all right? So typically, that's maybe the most common deadline is 15 days before the individual hearing. You have to have all declarations, all evidence, all witness lists, all applications, all country conditions documents, all expert witnesses, everything submitted to the judge 15 days before your hearing. Okay? But some judges require 30 days before the hearing. Some require 45 days. Some require 60 days. Some require more. Like, you've got to know what the order is for your case. Look at the scheduling order that the judge has given you. Pay attention to any notices that have been given to you by the court. Like, read them word for word to make sure you understand every single thing in them. Read them with your lawyer if you have any confusion or doubts about it. You don't want to miss a deadline ever. Okay? Um, and what happens if you do? Imagine you have an application for asylum and you miss the deadline. Well, now that the application could be not admitted into evidence, and they could say, hey, you waived your right to apply for asylum because it wasn't filed on time. That would be really bad. But two, they could say, look, you've missed the 1 year filing deadline, if that's the deadline that we're talking about. Or three, it's like, okay, what if it's something lesser than that? What if it's a key piece of evidence, but it's not the full application? Like it's the declaration from your aunt who was explaining to the judge all the instances that she received people coming to her door and saying, hey, where is my nephew? We want to kill him. And they're coming to her door with guns. All right? Imagine that's the document that was submitted late to court. Right? Well, a judge could just say, no, we're not accepting that document. Sorry, it was submitted late. Right? They have the power to do that. And if the judge doesn't review that document, they might say, hey, you didn't have enough evidence to even make me make a decision on your case, which means they're denying your case. Right? Missing calendar deadlines can make the difference between winning and losing. So don't miss any deadline. All right? Okay, and thing number one, we're to the end. We've gone through 6, 5, 4, 3, 2, and now thing number one. Number one mistake that I see, and I see it almost daily, all right, is not putting the time into your case that your case deserves. Not putting the time into your case that your case deserves. Number one mistake. You know, an attorney mentor of mine, when I was just getting started, suggested and recommended to me, taught me, that for every 1 hour that you're in court, we should be spending at least 4 hours of preparation out of court. Think about that. For every 1 hour in court, we should be spending at least 4 hours reviewing this particular case out of court, minimum. Think about that. And that's as the lawyer. But what about as the client, as the person, right? It's like practice instead of a game in sports, right? You've got to spend the time in practice so that when it's game time, when you're at trial, when you're in front of the immigration judge, you are prepared, you've rehearsed what you're saying, you know all of the evidence that's in your case, you know what questions to expect so that you're not thrown a curveball. All right? You're ready to you're ready to address anything that the judge might ask you about your case. Like, don't work the day before your individual hearing. Don't go to work that day. Take that day off. All right? Use that day to review everything in your case so it's fresh in your mind. That hearing is the most important thing in your life. It will decide your future. Like, treat it seriously. Put the time into it that the case deserves. All right? That's like my number one pointer today. So those are them, everybody. Those are them. Those are the 6 most common mistakes that I see that people make when they're in immigration court. And I'll repeat them real quickly for those who have tuned in later. Number 6 is not having an immigration lawyer. You want an immigration lawyer. All right? You want one who's good, who knows the law, who you trust, and who's going to put the time in. Number 5 is inconsistencies in the record. You want to avoid inconsistencies. Number 4 is not appealing your case. If you lose, preserve your right to appeal. It's a fundamental right. It's a due process right. Mistake number 3 is not challenging the government's allegations. all right? Just because they're written on some government document that some officer prepared doesn't mean they're true, doesn't mean they're accurate. Sometimes you want to challenge them. Number two is not calendaring critical deadlines. You don't want to miss any deadline ever in court. And mistake number one is not putting the time into your case that your case deserves. Got it? Those are them. Those are them, everybody. Thanks. So I'm going to give you a bonus. And the bonus is that on our website, I have my book. I wrote this book. It's called There Is Hope, Your Guide to Winning in Immigration Court. And on our website, under free resources, I mean, you can buy it on Amazon if you want to for $23.50, right? Or if you go onto our website, you can download this book under free resources, absolutely free. It's in PDF format, but it's absolutely free. I recommend you check it out, all right? If you're in immigration court, why wouldn't you want to fully understand how immigration court works, okay? So there is just a little bonus for everybody for being here. And now I want to stop and I want to turn it over to any questions that you have, answer anything that's up for the audience. So I have received a couple, and I've just received a couple. So I'll answer them and send over any more that you might have, and then we'll wrap up and we'll do this in Spanish, okay? So Veronica, I see your question. Thank you for asking it. Veronica, you ask, hi, I'm sending a U visa and I need a waiver. If I don't send the waiver right now, would I get a denial immediately or would I get a ride for it? Well, so the way it works is when you submit it, the easiest thing to do is to prepare your waiver at the outset together with your I-918, which is the form that you need to do for a U visa. All right? It is possible, and the waiver, just so I'm speaking clearly, the waiver for a U visa is on Form I-192. The I-192 is powerful with a U visa. It can waive all kinds of things, all right? Unlawful presence in the United States, immigration fraud in the past, permanent bars, deportation orders. The U visa waives a lot if it's done properly, okay? And so the answer to your question, Veronica, is do you need to submit your waiver at the outset? And the technical response, the technical answer is no, you don't need to submit your waiver at the time that you file the U visa. It is okay to file the U visa just with the certification from law enforcement, proof that you were the victim of a crime, proof that you cooperated with law enforcement, proof that you suffered substantial physical or mental abuse as a result of the crime. It's okay to do that and then file the waiver later. The benefits, though, the best advice, though, is to file the waiver at the time you do it so that you don't have to do double work. And what I mean by that is often when you're sitting down and writing the details about the crime that you suffered and about, how this affected you and how it affected your life, often it just makes sense. Like if you're already putting the work that your U visa packet will need into it, then hey, often it's just a few other extra paragraphs to say, hey, and my inadmissibility issues are this, this, and this, and please forgive them, and this is why I'll never do any other inadmissibility problem again ever, right? And then when you're signing the other forms, you can sign that form too, and you can just send it all off. Like, I don't know the benefit except for the cost. It's $930 of a filing fee to the government, but it saves you, in my opinion, thousands of dollars of extra work. Okay? And so technically, can you send the waiver later? Yes, you can. And is that recommended? I don't recommend doing that. I think that's a mistake that'll end up costing you. Okay? Food for thought. So the next question that I see here, and Veronica, if you want like more clarification about that, if you want to ask questions about that, I mean, my office submits U visas all the time. We would love to help you with your U visa if that makes sense for you. Okay? So Riaz, I see your question here. Let's see. He says, my friend applied for asylum. Can he fill the labor filing, labor application, maybe request your work permit? Is that what it is? I'm not quite sure. You need to finish your question, Riaz. I'm not quite sure what your question is saying there, but maybe he's saying, can he fill out the work permit? If so, I mean, look, after you apply for asylum, you wait 150 days, you can apply for a work permit. All right, if you did it correctly. Oh, okay. Riaz, you say he applied for a U visa today, how much time it's going to be for a work permit. Well, that's very different from asylum, right? So U visas, are super long, crazy long, 15 years of a process. And after 4 to 5 years, you should be eligible for a work permit through the U visa. Asylum is a crazy long process too, but not as long as U visas. All right, our longest cases right now are 5 years for asylum, but you can get a work permit. You can apply for it after 150 days. Okay, so it's very different types of cases. Hope that was helpful. Riaz, thank you for asking that question. The next question I see here comes from Alec B, and then I need to wrap up and we'll do this episode in Spanish, okay? So Alec B, thank you for asking your question. You say, hello, sir. My question today is, if I had the I-130 approved, but the I-485 denied, and I was put into deportation proceedings, can I appeal, or should I choose voluntary departure? It's an AOS case. So Alec B, thank you, all right? If your case was recently denied, you can absolutely appeal that case, that denial in immigration court. Sometimes that's the right thing to do. If you ask about voluntary departure, it depends, right? Voluntary departure requires a showing of quote unquote good moral character, which the felony charge you might not be eligible for voluntary departure. In other words, you'd have to look at that, talk it over with your attorney. You could, if you're eligible for it, I mean, you can make the request for voluntary departure in the alternative, and you can do both. Appealing doesn't mean you can't do voluntary departure. You can do both, right? Which means that you're requesting voluntary departure, but as soon as your appeal is filed, now your departure period is stayed while your appeal's pending. And if you win your appeal, then you don't have to worry about voluntary departure. But if you lose, then you have that time, typically 5 months after the appeal, to depart the U.S., 120 days typically. But read the order from the appeal denying your case, if that's the situation, to determine and talk to your lawyer too, to determine your voluntary departure window. It depends on how much time was granted by the judge for voluntary departure. Okay? I said a lot there. Hey, everybody, thank you so much for being here. All right? My name's Otis Landerholm. I really appreciate each of you being here, whether you're on Facebook, Instagram, YouTube, LinkedIn, TikTok. Welcome, and thank you for being here. If this was useful or helpful, please give us some love on the internet, like a heart or a thumbs up, or if you want more of these videos, the best way to get them is to subscribe to our channel in YouTube. All right, and then you can get additional legal updates and news. Landerholm Immigration is the handle in YouTube. Check it out. And if you have an immigration case, hey, please give us a call. We are here to help. We would love to help. All right. I see everybody here on Instagram. Thanks, everybody here. Ariangni Carelli. Hello. Sorry, I butchered your name. Gonzalez Henry de Jesus. Hello. Peter. Hello. Garjeto. Hello. DJ. Hello. By the Bay. Hello. Siddharth. Hello. To my friends here on Instagram. Love ya. Everybody, thank you all so much My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C., where we fight for your American dream. Join us on Thursday for the Empowered Immigrant Live, or join us next week for Deportation Defense Live. Thanks so much. Take care. Bye-bye.